Good morning or good afternoon, everyone. Welcome to the third webinar presented by Society for Product Safety Professionals this year. And the last two programs, we've been focusing on product safety management best practices. Today, we're going to talk about contracts and product safety. And the focus is going to be on how you as product safety professionals can help everybody else in the company, your company, be they contracts managers or lawyers, in determining what kinds of contracts are appropriate, what kind of suppliers you should be buying from, what kind of distributors, dealers, retailers you should be selling to, and what kind of ways you can protect yourself, the company, so that the risk is acceptable to management. So we're not going to make you a contracts expert, but we want to identify the issues that are involved and have you understand what's important for you to do your job and how you can be helpful to others in the company, also minimize the risk. So we have two great speakers. Let me introduce them. Oops, just a second here. There we go. Now we provided with the announcement lengthy descriptions of each of the speakers, so I won't go through all of those. But first speaker, John Cuppens. John is a lawyer at Nelson Mullins Law Firm in Columbia, South Carolina, and he is does a lot of litigation, but he also does a lot of advising on product safety and risk prevention, which is sometimes a little unusual for outside lawyers. So he is one of the guys who's got lots of experience in doing that, and I appreciate him participating in today's program. The next speaker, Heather Bramble, has done everything in this area. She's got a great varied experience, and so I think her perspective is going to be particularly interesting. She has been an in-house lawyer at Amazon. She is now in-house, although Heather, you told me you're not acting as a lawyer per se, but the head of regulatory affairs and retail support liaison at Mattel. And then she's also been a litigator. And lastly, she has been chief counsel to Commissioner Robinson at the CPSC. So every perspective that could be of interest here, and so that's great. So I think we have great speakers to talk about these issues and help identify some of the important things from all of our experience. Now, I'm Ken Ross. I'll be the moderator. I may also throw in my 2 cents here or there. But I've been an in-house lawyer for a number of years, and then outside lawyer for the remaining years. And more relevant to today's conversation, I've been involved in contracts for over 40 years as it relates to product safety and product liability. Okay, so a couple of slides and then we'll start in. What we're going to do is just, we've identified some important issues and we'll go over those. And each of our speakers will talk about these issues as we get to them. So first thing, chain of production and distribution. Nice colorful chart we have here, and look at all the different people involved in bringing a product to market. Design, manufacturing, distributing, retailing, lots and lots of people. Now each of these relationships, going from one box or triangle to another, or I guess pizza slice to another, could be subject to contracts. And they could be subject to both one or two contracts, depending on how the paper flows, which John's going to talk about first. But it could be an express contract, it could be an implied contract, but everybody's got a relationship. So when you look at this and say, okay, now something bad has happened, who's responsible? Let's look at the contracts. That is not an easy question. So contracts really are an important ingredient in trying to figure out who's responsible for what and who violates what and who gets to pay for this or that, depending on what happens. So the contracts impact safety, regulatory compliance, litigation, recalls, really, and every other problem or opportunity that can arise with all of these relationships. And we're going to focus more on the product manufacturer and then all of the people under that manufacturer. So we'll use the terms OEM, original equipment manufacturer, as the finished product manufacturer, the one that assembles or manufactures the finished product and sells it to a distributor, dealer, retailer. And then everybody under that OEM are tiers. That's the typical terminology we use. So a tier 1 supplier is the person that sells directly to the OEM. A tier 2 sells to the tier 1. A tier 3 sells to the tier 2, and then down the chain. So that's why it's chain of production. It is truly a chain, and we've got different tiers. So we're going to focus more on that and a little less on contracts between the manufacturer or the retailer and the end customer. Okay. So this is just another depiction of the chain of production and distribution. It looks a little simpler. We're not going to get too in depth on that, but let's just assume we've got, depending on the product, very complex relationships and many tiers on even fairly simple products. So, I mean, I've gone down to tier 5s, which make semiconductors that go into a device that goes into a bigger device, that goes into a bigger device, and gets into a finished product. So it is not unusual to have many different tiers involved in these kinds of situations. And again, there's contracts involved in each of them. So let's start with the topics. And the first topic we're going to talk about is, when do we have a contract? Oh, I'm sorry, before we get to John, I'm sorry, there was one other thing I was going to mention. This whole area also is impacted by the bargaining power that each party has, and contracts only go so far, as evidencing the so-called agreement. But you don't have to comply with the contract, and you can still not have a problem if both parties agree to it. So there's both the contract, and then there's what we call contract administration, contract management. Do we want to enforce it? Do we not? How do we interpret it? Do we have different interpretations of the contract? So a lot of that is governed by who has the most bargaining power as far as imposing certain terms and conditions on others. And secondly, how badly one of the players in this contract wants to keep the other one happy and do business in the future. So a lot of times the contract, and we as lawyers can help on the contracts, but we can't as readily help on business relationships we have with your suppliers or with your sellers. So that has a big impact on how the contracts are interpreted, enforced, and managed. So that also has to be thought of in determining whether you have a contract and what goes into that contract. Okay, I'm sorry, now the first topic. So we're going to talk about contract formation. When do you have a contract, and when are there problems in determining what contract has been formed and whose is it? Turn it over to John.
Well, thank you very much, Ken, and hello, everybody. It's a pleasure to speak with you. You know, Ken's right. I both represent product manufacturers primarily in litigation and also counsel them about things like this and other preventive measures. And in litigation, something's, you know, presumably gone wrong and you're trying to figure out how to deal with it. And here we're trying to kind of use the lessons from that experience to try and figure out, you know, how to draft contracts that avoid some of those problems. And in the area of contract formation, you know, one of the things that we just wanted to highlight for everybody is that some of the standard ways that contracts are formed might not lead to the result that everybody expects. Oftentimes, a seller has, you know, a document that he uses for an invoice or a quote, and on the back of that document there are standard terms and conditions, and those are the seller's, you know, belief about what the terms of the agreement are. However, oftentimes the buyer on their purchase order or on their confirmation also has their own standard terms and conditions. And oftentimes, since each one kind of drafts the terms and conditions in a way that are most favorable to its position, a lot of times the terms and conditions that the seller has and the terms and conditions that the buyer has are different in some respects. And that's where the legal concept of the battle of the forms comes into play. There are rules that kind of speak to what happens in a situation like that, where there are terms in conflict between the two forms. What we're talking about here are commercial contracts for the sale of goods. And in those situations, almost every state has adopted by statute something called the Uniform Commercial Code. And its terms would decide how to deal with these battle of the forms, this conflict between the two forms that the buyer and the seller has. And there are three basic rules. Obviously, you know, there are lots of details and nuances to all this, but for purposes of the issue spotting today, you know, we wanted you to generally be aware of the fact that number one, if there are terms in the two forms that are the same, then there's no conflict and those terms become part of the contract. Secondly, when there are terms that are in conflict, the Uniform Commercial Code has a rule that they call the knockout rule, which means that those conflicting terms, if there's an issue where the buyer says one thing and the seller says something else, those both drop out. And the UCC has provisions in it that they call gap fillers, and those are actually will become part of the contract. So what that means is that the contract, you know, might have terms in it that actually neither the buyer or the seller didn't have in their forms and maybe didn't intend. So that's just, you know, something to be aware of. And then the third thing is that, you know, a contract is formed essentially by an offer and an acceptance. So a purchase order and an invoice, for example. And whatever the second of those two forms is the acceptance. And if the acceptance adds terms and the offer document doesn't prevent that, then those additional terms might also become part of the contract. So just kind of at a very high level, you know, we wanted y'all to be aware of that in this kind of very common way of doing business, especially with one-off customers, of sending a document with standard terms and conditions, there are a lot of circumstances in which those may not actually be the terms of the contract that you end up forming with the other party. And so there's a lot of thought that needs to be given to what to put in those terms and conditions to try to maximize your chances of your terms being part of the contract. Now, the best way to avoid this situation is to enter into a master supply agreement between the buyer and the seller. And in that situation, you've got a contract that the terms are negotiated between the two parties, and it represents what the two parties kind of agree on. And there's no you know, statute that's kind of filling in terms for you. So this is definitely a best practice. And it's definitely something that we would recommend doing when there's an ongoing business relationship between the two parties to the contract, or if you ever have a major transaction. But we also recognize that as a practical matter, when you don't have circumstances like that, sometimes the parties don't always take the time to draft and negotiate and enter into a master supply agreement. And in those situations, you know, we wanted you to be aware of what can happen when you're relying on your form terms and conditions. The only other thing I wanted to mention is that when you have a contract for the international sale of goods, there's a treaty called the United Nations Convention on Contracts for the International Sale of Goods. It's also known as the Vienna Convention. You have to expressly exclude that in your contracts for the international sales of goods, or if you don't, then that treaty could very well regulate contract formation and other issues related to the agreement. So that's kind of my summary of the battle of the forms and some of the things you just need to be aware of when you're dealing with terms and conditions.
Okay, thank you. Heather, do you have anything that you want to add?
Yeah, I was just going to call out, when it's all happening in real time, I think sometimes it's concentrated between either the lawyers or the business people and not always the product safety people. And one of the things is when you're especially for instance, on a master service agreement or master supplier agreement, obviously those are always the best to have in place. The work orders or the purchase orders will follow from that. But that's a really key time when it's really important for the product safety professionals to be able to get some say. And I think we're going to go into that in more detail as the call as we go through the call. But when your business people are saying, we're going to do this big master service, we're doing it with the lawyers, that's when product safety people need to step up and say, all right, make sure you've got the key safety provisions in that agreement, because once that agreement is set, and we do think that's the best thing to do, is to sort of have that overarching agreement, everything's going to flow from that and you're going to miss your chance. So I just wanted to call it out as we're sort of setting up how we're talking about these contracts.
Yeah, and I just have one comment. But a lot of the things we're talking about on best practices particularly apply to what I call, and I think others call, safety critical parts. So if you're an OEM, you're a tier one, and your product has many components, you don't have to pay that much attention to it on every part, but certainly the safety critical parts. So you as a safety professional need to help identify which ones are really important, because that will help you determine what the contract should be. Should you buy them from somebody else? Should you buy it from somebody in a foreign country or not? And if so, how do you protect yourself? So identifying safety critical parts right during the design process will help you determine whether you want the kind of agreements that John and Heather are talking about, and how much attention should be paid to that, and what kind of procedures can minimize risk. The last thing I'd say is, the last thing you want to do is have a judge figure out what the gap fillers are in your contract. They have no idea what to do. I mean, the buyer wants a 1-year warranty and you offer a 90-day warranty, and they conflict. So what's the judge going to do? I mean, there's no basis really for filling this stuff in other than reasonableness. And you may not like what the judge does on it. And it costs a lot of money to do that. So having judges figure out what your contract is really a terrible thing to do and to rely on. Okay, thank you. Let us now talk to the contracts themselves, and what kinds of provisions or what kind of people should be involved in this, and how do you get your people, the safety professionals and others within your organization, to be involved in the contract formation process. And I'll ask Heather to start on that. You're muted.
Sorry.
Okay.
Thanks everyone. So yeah, I think this flows right from what we were just talking about. And, following up on what Ken said, I think there's a couple of different places that product safety professionals need to sort of key in on when these contracts are being negotiated, or, where you're approaching either suppliers or retailers on doing these business transactions. And obviously, the product safety professionals are not the ones negotiating the contracts per se. But if you look at it, like if we look at the chart that Ken showed in the beginning of the sort of the wagon wheel, right? You've got the product manufacturer in the middle. And obviously you've got your salespeople, you've got your commercial teams going out, buying the raw materials, buying the supplies, and that's all coming in. And if as Ken said in the beginning, there has to be sort of this cross-functional team that's looking at product development and then product manufacturing. And obviously product safety fills a really specific role throughout that process. Not only are product safety professionals needing to be weighing in on the design of the product and the safety of the product, how the product's going to be used, misused, and distributed, but also what kind of what kind of supplies are you going to be using? And then in terms of working with those commercial teams that are going out and getting the supplies, like, are there any standards? Are there there any, health and safety issues regarding those supplies, whether it's chemicals or it's, making sure that there's de minimis lead in a specific formulation or in a paint that you're going to be using for the product, whatever that might be. You need to be able to identify those key areas so that you're not involved in every contract, because that would be like just unwieldy and not a way to do business. But on the key areas of the product, the supplies that you're getting, the product safety has a voice at the table to just be able to say, look, you guys are going to go negotiate this. Here's the key things. We need to make sure it meets this, this, and this on a regulatory standpoint, and this, and this on a safety point. And if you have any questions, get back to me. But I think it means having like a very much a hand-in-hand relationship with your business or legal partners, depending on who's doing the negotiation and who's carrying out those contracts. And then on the flip side, you've got the same thing going on, probably with a totally different business team, a commercial team, and a different legal team sometimes on selling the finished products to the distributors and the retailers, depending on where you are in that supply chain. And again, you then can actually be almost like a business enabler. And that's what I always try to sort of stress to my legal partners, that on the other side of the relationship, putting in information about the safety, because you now know that the product is safe, has used the right materials, has used safe chemicals, does have a safe design. You can put that in and be able to sell the product even more, right? Because retailers are going to want that. Now, if you look at the other side of the coin, right, if you're on the retail side and you're a safety professional, you need to be looking that those key elements are in those contracts. Again, I think it's having this hand-in-hand relationship with whoever it is, whether it's legal or business. I mean, I can tell you that when, sort of thinking about it in real world examples, when I was at Amazon, I was legal counsel to the private brands division, right? Amazon Basics and their general product safety. And this came up all the time with, who were the business the key business people who were negotiating the contracts to sell the products, whether it's we were selling it on our space or making deals with other retail stores, and who were the key business people who was on point to get the raw materials or having their factories make it, or however the supply chain came about, right? And to make sure that I knew who those people were, they knew who I was, and I was able to work with them as a safety legal partner, but also always bringing in my safety professional on the compliance side, because they know they're like deep into whatever the requirements are and the design of the product in a way that a lawyer isn't. So I wasn't so connected to what were the key elements of a product, like Ken said, the product safety critical pieces and how many suppliers may go into one specific product. So I think those are the, what I like to say is it's really about relationship building, much like many things in life, that you need to know who the right people are who are going to be having the leverage to actually influence these contracts, and then be able to give them the key information in a very succinct way, because there isn't a lot of time. That's another thing that happens with these contracts is it's happening in real time. There may be a master service agreement. It may be a one-off. You might have to replace a supplier at the last minute in order to get the product to market, and it's happening very quickly. So if you've got like a checklist of the key areas that have potential safety concerns on any given product, then you're able to sort of give that to the negotiators pretty quickly, and then they could confirm that that's in the contracts. The other thing I was going to call out is, there's sort of the manufacturing and the retail piece, and then there's this whole other world of licensing that comes up. And a lot of times product safety maybe is the last one to the table, the product safety professionals, when there's these licensing arrangements, and they're very complicated, they're super complex. And again, I think it's making sure that for any particular product line, whether you're buying it or selling it, the product safety professionals need to be in the loop to understand what's the safety critical issues, and then be able to voice their concerns and send in very succinct way to the key negotiators, like, this is what you need to be looking out for. Like Ken mentioned before, like one big one, recalls. That's always going to be involved in any contract. Like product safety people should be weighing in to make sure that that's in line with with what your recall strategy is going to be. And I think we're going to get to a couple of other those issues as we go. So I'll stop there and see if we have any other comments from the group here or
Okay.
questions.
John, you have anything you want to add?
Yeah, that was an excellent summary. I would just, add that in my experience, this is like a critical area if you're trying to kind of stave off future problems, whether they're, recalls or future litigation, because, so many times in my experience, the problems that occur with a product trace back to a supplier or a sub-supplier. And so, like Heather said, communication is the key. And so as safety professionals, if you can help those who are drafting the contracts kind of understand the way these things can go wrong so that they can try to kind of, draft the contract in a way that either prevents those or allocates responsibility for those things appropriately, you've done your company a really good service. Things like, should there be the ability and periodic audits of suppliers? What kinds of certifications from the suppliers should be submitted to you that you can rely on? And, a big thing is if the supplier is making some change in the part or in the materials that it's using, or even in a process, you need to make sure that they tell you about that. I've definitely had situations where, a small part like prongs for a plug that you plug into an electrical outlet were changed. Nobody was told about it. And one of the approved part was approved, by a UL type entity, and the new one wasn't. And, not too surprisingly, there were problems down the road. And, after a bunch of investigation, they figured out what it was. And so, what you're trying to do is in the contract, instill the kind of communication that puts everybody in a position to avoid problems. And so it's a really important role.
Yeah, and let me just mention one thing that, well, we're not going to really talk about it, but you also need to evaluate your distributors, dealers, retailers. If the product can be modified by any of those levels through distribution, which could create a safety problem, you need to think about that from a safety standpoint and possibly address it in the contract. When I was an in-house lawyer, we sold table saws to a major retailer, and they wanted us to indemnify them for any problems arising from those table saws. Well, unfortunately, their salespeople would misassemble it on the floor of the store and sell it misassembled, yet they wanted us to indemnify them. Or they would advertise our products and show the safety devices removed from our product. Or they gave bad advice during the sales process, but still wanted to be indemnified. So evaluating in distribution also can be important in one, trying to minimize risk, but also trying to be sure that you're not agreeing to liability when it's really somebody else's fault. And that can be tough, particularly when you're trying to sell things to people. Okay, let's go to the next topic. So John is going to talk about warranty and a few things to look at, warranty and related subjects. Go ahead, John.
So again, the Uniform Commercial Code governs product warranties related to the sale of goods. In big picture, there are two types of warranties. There are express warranties and there are implied warranties. So first, talking about an express warranty, that is an affirmative statement by, say, a manufacturer, which is kind of its statement or promise, if you will, about the quality of the goods that it's selling. And normally you might see in a warranty a statement like, we warrant that these products are free of defects in materials and workmanship. And a reason for a manufacturer or a seller to make an express warranty is because it gives that party the ability to define the terms of what the warranty is and what they're willing to offer. And so they kind of, it's a way to exercise control over the process. So like, for example, The seller can say this warranty is the sole remedy that the buyer has if the warranty is breached. An express warranty would typically include things like, what are the types of things that the warranty covers? You know, like I said, if you have a defect in the materials, or if there's a defect in the workmanship, then, you know, that's going to generally be covered by the warranty. You can say how long the warranty period is. So, you know, that could be a year, or like Ken said, it could be 90 days. It just kind of all depends on, you know, what you want to do. It also includes notice provisions. In other words, if you want to make a claim, here's what you have to do. You have to do it within this time frame, and you have to send this kind of information to this place. And it's a way to kind of, you know, make sure that, you know, warranty claims are submitted to you in a proper manner and in a timely manner so that you can respond to them. A warranty talks about, an express warranty talks about, if the warranty is breached, what is the remedy? You know, is it repair? Is it replacement of the product? Is it a refund? Could it be any one of those? Oftentimes the warranty would say it could be repair or replacement, and it's up to us to decide which of those we choose. In other words, maybe they want to see if they can repair it, but if they can't, then they would decide, okay, we're just going to send you a new product. The other thing that a warranty should cover, and most usually does, is the kinds of things that the warranty does not pay for, does not cover. Examples of things that are generally not covered by a warranty would be, you know, if the product was abused, or if the product was misused, or even, you know, if there's normal wear and tear. You know, if something is just been used a lot and it's not really defective, it's just been kind of worn out, oftentimes warranties won't pay for that. A lot of other things they don't tend to pay for are if you know, don't follow the directions, you modify or alter the product, if you didn't install something properly or assemble it properly, or in a more of a commercial setting, if the buyer represented that the product was going to be used in a certain conditions and that's not what it turned out to be. So under all these situations, a warranty claim could be rejected for not being covered by the warranty. Under the Uniform Commercial Code, an express warranty can also set forth limitations on the damages that are recoverable. So, for example, a contract can state that, like I said, that the remedy is the buyer's sole remedy, and that remedy may limit the buyer's options to return of the goods and repayment of the price, or to replacement of the non-conforming goods, or maybe just a part of the product. And the contract can also say that the seller is not liable for certain damages. Traditionally, you know, you're going to be responsible for direct damages. In other words, what the buyer received versus what was promised. But it's very common to exclude other types of damages. And examples of that would be incidental damages. So those might be, for example, expenses relating to inspection or other things that led to the buyer rejecting the goods. A big one is consequential damages. And that's basically damages other than to the product itself. So say, you know, a product failed and it was critical to the buyer's business, and the buyer says that I had business interruption and I lost contracts and I lost profits as a result of that. It's very common in a warranty, in a contract, to limit consequential damages. Other types of damages that might often be, you know, that the warranty might not cover would be punitive damages, which are, you know, damages not to compensate somebody but to punish them for wrongdoing, or exemplary damages where there are some statutory treble damages. Now, those are all things that you might want to include in your contract, and you might want to talk to your lawyer about whether to include in your contract. And they're going to be, sometimes they're enforceable and sometimes they're not. It depends on the particular state's law and the particular circumstances. But the idea here is that, you know, you're trying to have an allocation of risk that's negotiated between the parties. I will say not all types of damages can be limited. One exception is under the Uniform Commercial Code. It's kind of as a matter of public policy deemed unconscionable and therefore unenforceable to limit the recovery of consequential damages for injury to somebody in the case of a consumer good. So if you've got a personal injury lawsuit where somebody's saying they were hurt by a defective product and they brought a breach of warranty claim, your ability to limit or say they can't recover consequential damages is probably not going to fly. However, on the other hand, in a commercial transaction or when there's a damages from a commercial loss, property damage, that kind of thing, then you can limit these consequential damages, things like lost profit and business interruption. I would also note that, one of the kind of core concepts here is that when you say what the warranty is, it's for this long and here's the promise we're making. And if we don't fulfill that promise, here's what we're willing to do. That promise needs to work, and so if for some reason the warranty just they call it failing of its essential purpose. If you keep trying to repair it and you can't, and you don't have a replacement, then that may open the door to you having to do something other than what you promised to do in your warranty. So that's kind of a summary of express warranties. The other major category of warranties is an implied warranty. And as the name would indicate, in this situation, there is no affirmative or express statement by the seller. Instead, the law imposes on the seller an obligation that when they sell goods, it's implied in the law that those goods are merchantable. For example, one of the main implied warranties is the implied warranty of merchantability, and that means that the law presumes that a merchant who's selling goods is selling goods that are merchantable, which just means that they are average quality for these type of goods, that they're fit for the ordinary purposes for which these goods are used, that if it's a large batch of goods, that they are kind of, the variation among them is within reasonable limits, that they are adequately contained and packaged and labeled, and that products kind of conform to the representations on the labels and the other accompanying documents. So that's the implied warranty of merchantability. If you breach that warranty, you can be liable under the law for damages caused by that. Another implied warranty is an implied warranty of fitness for a particular purpose. Implied warranty of merchantability is kind of more general. Implied warranty of fitness for a particular purpose is when the buyer is telling the seller that they need these products for a particular purpose, and the seller is warranting that these goods are suitable for that purpose. If they turn out not to be, then the seller might be in breach of that implied warranty. A seller can disclaim implied warranties. A manufacturer can disclaim implied warranties, like warranty of merchantability and the warranty of fitness for a particular purpose in certain circumstances. So that's definitely something in consultation with a lawyer that should be considered and included in a contract. And whenever you are disclaiming implied warranties, the law says that it needs to be in writing and it needs to be clear and conspicuous. And what that usually means is putting the language in all caps or in bold text, or sometimes both. So that's kind of a recap of warranty issues.
Okay, Heather, were you going to contribute or not on this one? I forget.
Actually, I had one thought on that, and I'm just going to keep repeating it because I think it's so important. The thing about the warranty issues that happen is that most likely your legal partner is going to be heavily involved in that with the commercial commercial point people, right? And because this is going to be key, this is a key element to any of these contractual engagements, and it's just super important that the product, like the product safety person, isn't going to come up with the warranty. But what's going to be really important is like what is that checklist of things, because you need to be working with your safety professionals and your quality professionals, right? Your engineers on like what if you're the one selling the product, what, or the component or the material, like what is it that where do you reach the end point where the product isn't going to be able to function anymore, or maybe it can function but it won't be safe. And the people negotiating these contracts aren't going to have that information at their fingertips, and you are so critical to that conversation. And also just being able to distill that to some key points, like, hey, you know, this thing is, it works after 7 years, but it's not safe, and it's not safe and it doesn't work after 8 years, whatever it might be. To be able to give that information in those warranty discussions is critically important.
Okay, and I just have a comment on this too, as I always do, I guess. You know, a lot of times, let's say I'm a tier 1, a tier 2 supplier, I may just warrant that my product complies with specifications, and that's it. I don't warrant against defects in material and workmanship. So you got to look at what your suppliers are going to warrant. What are they going to agree to do? Now, interestingly, and I've never done any research on it, materials and workmanship almost sounds like manufacturing defects. So it's an interesting question. Are they warranting the design? Are they warranting the warnings and instructions, which are both pretty vague as to what's a defect in designing warnings and instructions? So exactly what do they mean by the warranty, and what are you getting? If I were advising a component supplier, I'd try to limit it as much as I can so that it is clear. I met specs, period, or I met standards, which we're going to talk about in just a second, and that's all I'm warranting. One other thing, and this shows the difficulties here. Let's say I'm a tier 2 and I sell to a tier 1. I give them a 90-day warranty. I say that that my only liability is that I will replace the defective products, and I disclaim all other liability. And then the tier 1 contracts with the OEM, and the OEM wants a 1-year warranty, and they want the tier 1 to be responsible for all costs involved in any problems, not just replacing the part, the tier 1's part. So now you've got a conflict between the two, not in the contracts, but the tier 1 is stuck in the middle. They're responsible for all the problems caused by the tier 2, but the tier 2 is not responsible for all the problems their component creates. And we'll talk about this in connection with recall costs, which comes up all the time. But so you can have this conflict. So when you're looking at the contracts and what have you as a company agreed to do, you need to look at both the your purchase contracts terms and conditions from your suppliers, and what you're selling to your OEM or your tier 1 or wherever you are in the chain, to try to really figure out what liability have we assumed. And you can't just assume that only one contract applies. They both apply, because you're right in the middle of 2 sets of contracts. Okay, so we're not trying to make you experts on this stuff. I want to hopefully convince you that this is pretty complex stuff, and but you play an important role in trying to help the company and those who make decisions on what risks you're willing to assume. Make those decisions, a business decision ultimately, about who to buy from and who to sell to, and what kinds of terms and conditions are acceptable to management. Okay, the next subject, and it's very related to what we just talked about, and that is compliance with standards. And how do you get people to do that, and what do you make them do? Heather?
Yep. Great, thank you. And so this is interesting, right? Because in the products, so this is something product safety professionals are super aware of, right? We've got voluntary standards, we've got mandatory standards, and then we've, and in addition to that, we've got certifications, which can be voluntary or mandatory. And you have to then take a look at the world, right? Because we've got regulatory compliance that includes voluntary standards and or mandatory standards, and it may be different depending where you are in the world. So it starts to become not just a commercial transaction, like put in, sometimes people will put into contracts, meet all applicable standards, right? That's a common contract term. What does that term mean? And, you know, the lawyers will say, well, we'll just put in the biggest term, the biggest clause ever, meet all applicable regulatory compliance legal standards, but that might not include voluntary standards unless it's called out. So this is another place where if you're involved as a product safety professional, you really have to think about which are the applicable, you know, voluntary standards. And that's a strategy, like an overall company strategy. Like, are you going to meet voluntary standards even if there are no mandatory standards? Is that obviously best practices say yes, but then the question becomes, what if you've got competing voluntary standards in different areas of the world that you're selling? And how do you make sure that your suppliers are meeting all of them? And so that's something, you know, you have to kind of look up the supply chain and down the supply chain and figure out, do you as a manufacturer have to come up with your own set of minimum requirements as a safety professional and share those with your legal and commercial counterparts? So if you're manufacturing products in China and you've got your product design and you're getting raw materials from all over the world, but then you want to sell your X product in Europe, Asia, and North America, and there are different requirements, what are the minimum that you have to meet? And that might be voluntary, you know, certain voluntary standards and mandatory standards, and they may be different. And that you have to have that written in, or your suppliers aren't going to meet it, because suppliers aren't, you know, they're not mind readers. They don't know where the ultimate finished good is going to go. So you have to set up a bar, a minimum bar of all the requirements that any particular supplier or raw goods supplier, you know, or component part supplier has to meet to go into your product. And then, you know, this is critically important, because on the other end, your distributors, retailers are going to be asking, do you meet the applicable, you know, we sell in X, Y, and Z country, do you meet them? And unless you have those terms written into your upstream contracts, you're not going to be able to make those commitments downstream, and it's going to become a huge issue. One way companies deal with this is like creating their own sort of protocols internally, so that they know like the areas of distribution that they meet, and then they can sell there no problem. And if you want to branch out to a new area, then you have to reassess what those requirements are. And then remember that you have to go back to all your supplier contracts and your component parts, raw materials, to confirm that all those meet any new requirements that are out there. I mean, one of the other things that that often comes up is that when you're dealing with potential changing standards, that, you know, the manufacturer has to be super aware when those things happen. So if there's you know, different chemical, and this is happening around the world now because of sustainability and recycling and packaging, if the limits of certain chemicals, right, we've got the REACH chemicals in EU, they're always adding them, we've got a lot of sustainability components that people are sort of replacing different chemicals with other chemicals. Like, how does that affect your already in place contracts of supplies that you're getting? And how do you then potentially make representations to distributors or retailers? And so that's where the product safety professionals, you're the only ones that are going to know. That's your space. That's the space that you own, to be able to give your business contacts, like, look, we see this is going to be transitioning in 6 months. This chemical is going to have to be replaced. We have to get it out of our supply chain. It's a product safety issue, and it's going to come up in our, you know, our current contracts going downstream. We're going to have to make those commitments going forward. And how do you get it out of your supply chain? And how do you do that using your partners in terms of contracting, so that your suppliers have to replace, you know, ahead of time, in enough time to get it into the finished goods? I mean, those are some key issues that happen with the standards. And then also, when, you know, even just performance standards, right? We have in the US, we've got ASTM standards, mandatory standards for children's products. And when those change, how do you know, you need to be updating your internal stakeholders of of things that are coming down the pike. Many of you may be involved in ASTM meetings, tracking these issues. That information has to go to your commercial teams and your legal teams on a regular basis so that they know what any changes, if any, have to be made for in the contracts going forward. And when you have to go back to suppliers to say, look, we're at X date, implementation date, this has changed, can you confirm, right? And then the flip side of that is if they're changing stuff without you knowing, because let's say they think, oh, this standard change, we want to change this. Is that in line with your supply chain? Are they giving you notice that they're changing different chemicals or different products or different component parts into like whatever product they're selling you, so that you'll know what's changed in your product? And does it meet the voluntary standard? Or does it meet the mandatory standard? And does it affect where you can sell the product to on any, in any given shipment? And do you know, like, do you have the ultimate visibility to know these sets of products need to end up, meeting these standards, and these sets of products need to meet these other standards? And, it happens all the time on the quality front, right? You can't sell you're not going to be selling US plugs to the European market. But on the other hand, you need to also know, like, whatever safety standards they're meeting, it has to be the same analysis. And so the other piece that I think is really important is that safety professionals work very closely with the quality professionals. And a lot of times they're the same people, depending on the size of the company, but funneling that information to the commercial partners is really important, because they just have no window into that visibility. They're selling a widget, and the widget can go anywhere and could be anything. They're making a sale. And so that's where this point of view is super important to make sure that all the right standards are met, and that the company isn't getting itself into any issues where you're selling in the world, and what standards or certifications you're meeting.
Okay, John, you have anything you want to say?
Yeah, I would just add that, like, from my experience as an outside lawyer, some of the most challenging issues are, if something happens and, the facts might give rise to, for example, an obligation to report something to the CPSC, and the issue is kind of caused by, really something that was the responsibility of one of the component part suppliers, or, some other kind of partner with the OEM, then the questions of who's responsible for reporting, or maybe more importantly, who decides, whether a report should be made, and then who controls, the conversations with the regulator from that point. That's a really important point. Oftentimes, the manufacturer, it's their name on it, and so they are desirous to be in control of those conversations and those decisions. But at the same time, if it's really the fault of the component part manufacturer, would the manufacturer want them to step forward and take responsibility, or at least reimburse or pay for the costs of those actions that need to be taken? All of those are very challenging decisions that kind of are, dependent on the particular circumstances involved, but really important.
Okay, and I just want to say that many standards out there are performance standards, not design standards. So it is very possible for your supplier or you to meet the standards, to comply with the standards, and spell out a defective design. And so, so what does that mean? Compliance with standards, exactly what standards apply? Are they mandatory? Are they voluntary? Also, there could be some inconsistent standards for different parts of the product. And then when you throw in foreign sales and you start talking foreign standards, now you've opened up a big can of worms, because there are multiple standards. And if you sell internationally, you already know that there are different philosophies in different countries about safety. And therefore, there are different standards, many more standards in the EU than there are in the US. I think I saw in an article that Acting Chairman Bob Adler said there are around 70 CPSC mandatory standards, not very many. So there's all kinds of places where there are voluntary standards, There could be competing voluntary standards. So that's one issue to think about when you're trying to specify products and what they comply with. And the last thing is you can have inconsistent testing results. So I've had situations where on bike helmets, for example, the manufacturer tested it to 3 different testing services and it all passed. And then the CPSC tested it and it didn't pass. And Consumer Reports tested it and it didn't pass Consumer Reports tests, which are actually different from the CPSC's tests. So when you start talking about compliance with testing results and standards, it can be fairly difficult to determine compliance or non-compliance. And so the clearer you can be exactly what you're talking about, whether you're a purchaser or a seller, the better you're going to be. Okay, we're going to move now. I think what we're going to do, we only have time for one more topic. There are 2 at the end, you'll see in the slides, which are important here, but they're also related to litigation, a little bit more related to litigation. So maybe we'll do another webinar in the fall on litigation. So product safety as it relates to litigation, because one of the things we're talking about today and can talk about later is how to prepare for litigation during the design and manufacturing phase. Ultimately, you expect you could be sued, an accident could happen. How do you protect yourself in litigation? So we may have to hold the last 2 topics. But the next one I want to talk about is one of my favorites, and that is recall costs. Heather mentioned that. It's usually a part of any discussions. Although in my experience, over 40 years, is rarely does a seller want to talk about recall. They're trying to sell their product. I mean, the marketing, the sales department doesn't want to talk about, gee, who pays if we have to recall the product? They never want to admit there could be a recall. So trying to get the seller to even think about that can be problematic. They would rather leave it vague and hope they can not have a recall, or if they do have one, maybe they've bought recall insurance and they don't even have to deal with it. Now, the buyer is interested in who pays for the recall. Some buyers, though, don't pay a whole lot of attention to that either and figure that under the warranty provisions, unless they clearly disclaim recall costs, that it's covered. That is, as John said, consequential damages would include recall costs. So sometimes it's really hard to get anybody to even think about it, whether they're on the sales side or the purchase side. Well, that's a bad idea, I think. And I will admit that some lawyers would rather it not be very clear either, because they would rather just assume that, the salespeople don't want to talk about it, but also they don't want to make it that clear because they don't want to commit to one way or another to even be responsible for recall costs. So, but within those kinds of paragraphs, if they are addressed, who has the responsibility to monitor the product in the field? Who decides on who reports? Is it the OEM? Is it the tier 1? Is it the tier 2? Does the OEM have to get permission from the tier 1 or the tier 2 before they report to the government? Is that required? So it's not just the recall cost, it's everything surrounding a potential recall. Then, of course, importantly, who pays for what? And what are the reasonable expenses? Now, if you do what John said, you're going to try to limit your liability. So if I sell $10,000 worth of parts to a tier 1 or an OEM, I'd like to limit my liability to $10,000 or replacing the product, at my choice. Well, the recall could cost millions of dollars, even for $10,000 worth of components. Well, who's going to pay for that? Now, as I mentioned before, many times the tier 1 goes to the OEM. The OEM wants the tier 1 to be responsible for all recall costs. And the tier 2 only wants to be responsible for $10,000 because that's what their price was, the contract price was. So the tier 1 is in the middle and can get stuck for paying for full recall costs when it wasn't their fault. And so that is a huge issue to be considering. And do you want to buy from a tier 2 who limits their liability to $10,000 of the price of the products? Well, the tier 2 is going to say, hey, I don't make enough money on a $10,000 contract to pay for millions of dollars in recall costs. So if you don't want to agree to that cap, I'm not going to sell to you. And the tier 1 has no choice because they have to buy from a small manufacturer, small components. So I find my perspective is fairly, I'm greatly interested in it because I serve as an expert witness in litigation on recalls and recall insurance and reporting and recall costs. And this is really hard stuff because everybody disagrees on it depending on which side you're on. So either leave it vague and hope you never have a recall, but if you do, then you're going to have to mostly rely on your relationships and your ability to pay for these costs to decide the issue. And a tier 2, many times they'll just say, fine, I'll agree to full recall costs, but if it ever happens, I'm just going bankrupt. Period. I'm out of this. Don't bother me. So is that really the kind of supplier you want to deal with or not? So it's very difficult to know exactly what to do. It's very much related to bargaining power, certainly within the automobile industry, and I do a lot in auto components. You want to sell to a big OEM, you're paying full recall costs as a tier 1. But the tier 2, tier 3, they're not going to pay for full recall costs because they're selling small components. So if you want to sell to an OEM in the car industry, you don't have any choice but to agree to full liability for that. And then it's another interesting question, whether you can buy recall insurance and whether that's really going to protect you. So in any event, it's an issue to be very cognizant of, and it's a business decision ultimately as to what you do and what you agree to. Now, I will say I think we only had one question in the chat room. I apologize. We can post the answer in the website. If you have other questions, let me get to this last slide. So if you have questions still remaining or they come up afterwards, you can email us at this email address and pose the question. We will post these slides, a link to the webinar archive. So if you have somebody else in your organization who wants to listen to it, they can do that. And we'll maybe try to provide more contracts material. If any of you are willing to provide sample contract forms or other information related to safety and contracts, we'd be happy to post those under the webinar series. We will be adopting a new page in the website soon called Ask the Expert, where anybody can submit any question about anything related to safety, and we will find somebody to give an answer and we will post the answer. So that can apply certainly to the contracts issue or any other issues that you're interested in hearing an expert opine about. So we will try to get you these answers, whether you've been allowed to or whether we've had time to answer them today or not. That's our goal here, is to give you as much information as we can and answer as many questions as we can. So utilize that email address and we will get this information and try to provide a response. But we'll also then provide some articles and maybe some contracts material in relation to the webinar series. So with that, I want to thank John and Heather. Thank you very much. I appreciate it. And thank you, Loudon, for managing the webinar. And I'll turn it over to you for any closing remarks you have. Thank you all very much.
Wonderful. Thank you all so much. And the webinar will be on the website in the next couple of days if you have someone you know that wants to watch the recording. And as always, we look forward to seeing you at our next webinar. Thank you all. Have a wonderful day.